Very good afternoon.
This is not the training. This is not the training program. It is just a virtual workshop. Everyone should contribute. Even all here, whoever there, all persons' average experience maybe definitely more than 20 plus years. And all put together, all the experiences, somebody may handle today's session, they may handle the already practical way also. There are a couple of cases they may handle. Hence, that's why it is not a training or some capacity building, not like that. It is just a virtual workshop. I may be the facilitator with certain presentation also. And I request you all can contribute. Yes, you may share your experience also relevant to this topic. And already introduction given, and being a banker, and currently I'm doing practicing IP, and also part of Meta and Meta Insolvency and Restructuring LLB Mumbai-based IP as a associate partner. There's a basic about me. Maybe I'll throw up the topic name. How many are already handled PPRP cases? Maybe you can put in chat box also. Yeah, my question is, already how many, maybe you may be already handling PPRP cases. Okay, maybe over the session, maybe if you are already handling PPRP cases, you can also share your experience. Maybe because of confidentiality nature in PPRP, you may not mention the company name and the other details, even the location details also not needed, but you can share, because PPRP cases are mostly confidential in nature. Now to present the rise of pre-pack, emerging trend in IBC resolution. Particularly, we are going to talk about only pre-pack PPARP alone. The background behind, maybe the presentation is about, there are three parts. One is basic detail about PPRP, though you may all know all the regulation, being IP, you may know everything. Here, I may again reiterate the PPRP rules and regulations. Then the background behind the PPRP. There are certain number of cases which are available in public domain, particularly PPRP cases, and my personal experiences with the few bankers and handling few PPRP cases. I'll share that also. It is like the next 3 hour session maybe. The first is the theoretical aspect of PPARP. Second is the current cases and their impact. Third is the personal conversation, and also there are you may also share your experience on PPARP cases. Now, moving to the topic, PPRP, introduction to PPRP, claims and critics. What IP, the currently looking for PPRP cases, what kind of, some kind of critics are there, what kind of critics are there still? And the timeline and objections, debtor in possession model, role of judicial oversight, something like that. Always people are thinking that PPRP cases, judicial oversight is very limited and it is in debtor control along with creditor approval, something like that. So what kind of things are there? That we are going to see. And proposed, maybe it is not suggestion, we are not, this workshop is not that purpose, but what kind of problem currently based by the IP, that is we are going to see. Understanding the pre-packed insolvency resolution process, it is applicable only to MSME sector. Because of post-COVID, the ordinance is passed 2021. It's a cost effective mechanism with a time bound. Time bound means when compared with the CARP, PPRP cases are completed within 120 days, 90 plus 30 days. And these are all the already their code itself it is mentioned. The common claims about PPIRP. PPIRP is an expedited procedure. People think that it is a very fast track resolution process. That's a common claim. And adoption of debtor is unlike CARP, that is creditor COC control resolution process. Here in PPRP, it is debtor in possessor model. Still the asset and company, everything handled by debtor, but with the approval of creditor. That's the common claims about PPIRP. And another is limited involvement of judicial authority. But that's a common claim. It is not always true. And critics about PPRC. PPRC is not fundamentally new. More or less, it's only time and the approach may be different, but still not fundamentally new because of nature. Because 2021 the amendment passed and now in practice. Still, it is in nascent stage. It is a rebranded version of the existing concept. That means in banking, OTP settlement, over-the-counter settlement, and the restructuring, reschedule. It is like a rebranded version of the existing concept. That's also critics about PPIRP. And there are certain misconceptions about judicial oversight in this process. That is also some of the critics are there. And PPRP claim to intended timeline, we all know that 120 days for completion as per IBC code. That is intended timeline. But looking at the cases listed in across India, even as like CARP, PPIRP cases also going beyond limit because of various other reasons. And another thing is, it is because of the timeline is very restricted, 90 days plus 30 days. Aims for value maximization is high. That is the intent. And promote timely resolution. Because of short nature, timely resolution is possible. But actual challenges is delayed due to various factors. It may be because of the approval of financial creditor and potential for value erosion also, where the MSME itself, a lot of challenges are there, and increased uncertainty in outcomes. These are all few challenges. And one more challenge is being a last 20 days, I have worked with multiple banks. The biggest challenge is that is true also. Bankers are using PPRP as a tool. They are negotiating with the debtor, and they may, if you are not settle your one-time settlement, something like that, we may put it in PPRP for IP process. Then the settlement may take the over-the-counter negotiation. These are the things that happen. It is not recorded anywhere. Actually, currently there is no system available. PPRP cases pre-negotiation stage, before putting applications to adjudicating authority, the process is not streamlined. Still, still IPs are involving along with the bank. Still, IPs are involving along with the debtor. But the system to capture those because of confidentiality in nature, it is not recorded anywhere. Even banks are not recording their these negotiations for PPRP application. It's all pre-stage, and bankers are using these as tool to address their existing issue. They have other way of SARFAESI Act is there. If it is going beyond SARFAESI Act, then one-time settlement, then the process negotiation. They also put it PPRP also one of the negotiation tool. It is not cases. Just they may use PPRP as a tool. That's also the biggest challenge. And another biggest, in banker point of view, sometimes the over-the-counter settlement, some kind of haircuts are happening, means the hierarchical level of bankers, something like a 10 crore haircut is required, means then they need to go to their own higher ups. At least in some banks it may go up to board level. Some bank it may be the executive director level. Because of these reasons, the stressed asset department, those who are handling stressed asset department, because of they may think their own hierarchical people, they may not give approval for one-time settlement. Then they may put it in PPRP cases, PPRP in their own stressed asset team, their own internal negotiation process itself, their own internal teams, they may use PPRP as a tool to get their own superior approval for one-time settlement, over-the-counter settlement. Actually, the IBC law is there. This law also used by bankers are use their own internal resolution process. That's also actual challenges. So IB are already involved in that process, but it is not listed. These are all actual challenges. And another, the objection versus interventions kind of things. The objection should be addressed within 14 days. Practically, it is not possible, but that is the, it needs to be done within 14 days. Can delay the resolution process, potentially expand timeline beyond 128 days also. This is listed in the recent case, 2024 case, Chris Realtech case. the PPRP cases going beyond. There is no the code or regulation. There is no time limit extension available for PPRP cases. But however, the by practice, it is going beyond 120 days. Maybe IBBA and the adjudicating authority, they may over the period they may solve these issues also. Quick the PPRP cases, quick resolution is possible. And intervention required in PPARP, it's a smoother process, can help clarify disputes between the creditor, debtor, these kind of things. Even the operational creditor aim for faster resolution, focus on procedural efficiency, less likely to extend timeline. These are all the perceptions about objections versus intervention. Timeline extension in PPARP, actually the code lacks clarity on the 120-day timeline as mandatory or directory. It is not clearly mentioned in the code also, but it should be completed within 120 days. There is no exception, whether it is a mandatory or directory. That needs to be clarified. But now NCLT, there are a couple of NCLT cases are there relevant with these things. And the NCLAT case, Ketos Tiles Private Limited case, I think we are going to cover that case exclusively in the case analysis also. Ketos Tiles Private Limited case, the description of extending the timeline was clarified in that case. Actually, extension was given, but in the code and the regulation, it is not there. The discretion complicates because the adjudicating authority have the power, but it is not mentioned in the regulation or code. The discretion, that kind of discretion, complicates the process. The overall objective of completing the case within 120 days may be questionable. These are all what I am currently, how in the market, PPARP cases, what kind of things are there, that we are talking now. And it's, everybody knows this debtor in possession model. Existing management control the company in PPARP cases. Provide a second chance for honest debtor. Maybe they made the debtor PPARP provide options to revive the company. That is possible in this PPARP model, because debtor here the company is still in debtor control. The only problem is creditor interest. Conflict with creditor interest also possible. But anyway, a creditor needs to, before admitting the application to adjudicating authority, creditor needs to, 66% of the creditor needs to give consent before putting application to adjudicating authority. Still creditor in control, principally still creditor in control company only, but operationally managed by debtor only in coordination with the resolution professional. There are possibility of potential inconsistency in PPARP claims. That is also possible because of debtor in possession things. There may be a relative party. A lot of things needs to be assessed because of still ownership lying with the debtor. Creditor in control principle, particularly the case, creditor has primary control. COC has full control. promote accountability and transparency. That is possible in CARP, not PPARP. That means IBBA and the AA, accountability and transparency, they are trying. But when compared with CARP, PPARP confidentiality is very high. Even that is not public. Even the admitted cases are not publicly available in the site also. There are pre-negotiation stage. Transparency is missing. And the public domain, we may not access what kind of problem that company is facing or what kind of opportunity available with the company. That is still very big problem in PPARP cases. CARP, the potential conflict of interest because of it's a COC control thing, that is minimized. And fair resolution, that's the industry. What I am currently putting the thought process, TIP model and the critical control model, it's a general opinion. It is not, it may be right or wrong. It's an opinion. Support of fair resolution in CARP. PPARP, because of confidentiality in nature, the debtor and creditor only knows all the nuances and it is not publicly available. The data is very limited. Judicial oversight in PPARP cases, initiation of process by NCLT, approval of plan through NCLT only, but it may take time. The pre-negotiation process, all the preliminary information memorandum, these are the things happen before putting application into NCLT. That kind of negotiation happen between the debtor, creditor, even with the resolution professional. And everybody we know that there is no, in PPARP there is no IRP. Everything only RP. Only RP. It is only resolution process. It is not a interim resolution process. It is, but still lot of difference between CARP and PPARP nature. Even the default amount is because of MSME nature just 10 lakhs. Anything above 10 lakhs, the case can be lodged. Only thing is, the company needs to be Udayam registration is must, and RP need to verify all those things before putting application into adjudicating authority, whether these PPARP cases fall under MSME. The NCLT role here is building the trust. Actually, as per code, it's a promised minimal inferences between adjudicating authority. Most of the things happen between debtor, creditor, and resolution professional. Resolution professional still here, he may play like a court appointed, the mediator kind of, maybe the resolution, the final approval anyway, the creditor need to give, and the debtor need to convince creditor, and we may be just intermediary between the debtor, creditor, and the maybe the NCLT and the whatever the direction given by the NCLT direction, RP needs to follow. And the speed and appeal, as per the PPARP code, just 90 days, everything, even within 90 days, the resolution is possible. And reduced judicial scrutiny because of the whatever the it's like a compromise between debtor and creditor. The whatever the required forms and everything filled means the judicial scrutiny is very limited, but still judicial scrutiny is there. And MS is on self-regulation. Both creditor and debtor, they need their own, maybe creditor, how they can maximize, and debtor, they can, how the company can be revived. That may be the debtor objective. Creditor also think that how, because anyway, if it's like a one-time settlement kind of process means, again it is the loss for bank, because anything, banker always want, company need to run, then only they may earn monthly income out of that debt. If it is closed abruptly, either it may be haircut, everything is there, it's a lost business. It is not good for the creditor also, it is not good for a debtor also. That's why these self-regulation play a vital role. Enhancing PPARP framework, I think it may be under process, and over the period we can expect. Out of court admission, currently it is all happened. Even if you have even one of the SBI stress asset branches, I handled few PPRP negotiation, but it is not put it in the application stage also. It's out of court admission. Something like before putting application to adjudicating authority, the negotiation happened between, in front of even the IP involved. That's also happened. If it is at one stage, the banker may think that whether resolution is possible and the potential applicant is there, and value maximization is possible, then banker may allow in NCLT. They may ask us to put it in case at NCLT. If they may think during the negotiation process, even the resolution is not possible means, then they may negotiate further with the debtor for one-time settlement. Then it will not come in PPRP case at all, but still they are using IP support. And another framework, maybe the out of court admission, how it can be channelized, maybe the platform within the purview of IBC code, how these out of court admissions can be tracked, and how many, because we currently even the NCLT cases are very limited. Something like 30 or 40 cases are there across India after 2021. Last 4 years, there are 40, 50 cases only listed. But in practically, that is not the case. Almost 100 times, even the cases are 40 means 4,000 cases out of court admission may be possible. Here, because there is no data available, but I am maybe based on the field reality, whatever currently listed is almost 100 times of cases negotiated in bank centers, or even the debtor initiated cases also still negotiation, because creditor approval is needed. It is in it's like another court, something like NCLT is adjudicating authority. Here parallel, there is I'm talking about the practical. Bankers behave like a adjudicating authority, something like that. But that is not the ideal scenario. But the banker may see that this may be the another they have reschedule option, resettlement of the reschedule, restructuring, one-time settlement, something like that. Another option is PPARP. That's also even number of cases, even that's all settled also. That is not tracked. I think maybe the regulatory authority may think how it can be channelized. Something like that needs to be monitored. then the IP effort, IP time, and there is no regulation out of if once put it in the NCLT, then there are IP fees and IP regulation, everything regulated, and anything is there, they can go to, anybody can go to any, even against IP, or even IP can go for their own solution. It may be remuneration kind, something like that. But the application is not, but with pre-negotiation stage is there, means there is no, only thing is the IP negotiation skill, IP relationship between the banks and the debtor, then that is individually monitored thing, individually, it's up to IP skill. And the limit NCLT intervention, because these negotiations, even the regulator think that it will resolve the case very quickly. There are code of conduct for corporate debtor also, and timely resolution. These needs to enhance. Both the things needs to enhance based on the existing. There are certain cases, landmark judgments are coming with PPRP cases too. There are another aspect of PPRP cases, that is PPRP along with the personal guarantor. Here in this, there are a couple of cases, even we are going to talk about those specific cases also, where the personal guarantor also involved in PPRP cases. But there are certain, even the code itself, even the PG, personal guarantor regulation, that is separate. The PPRP cases, that is separate. There is only now the few judgments are there. PPRP cases, if personal guarantors are there, how it can be treated. I hope there are certain code and regulation amendment may come over the period, but few NCLT judgments are there related with PPRP cases linked with personal guarantor cases. We are going to talk about few cases related with the personal guarantor also. And there are general, the current IBC, CARP one solution is there, PPRP solution is there, bankruptcy is there, individual insolvency are both individual and maybe individual insolvency is there only for currently it's only PG cases, corporate company only for PG. PPRP, in my PPRP is required among debtor. A lot of awareness, even bankers' point of view. I think banker may know all these things very well, but the only the division of stress office team across a bank, they may know everything about IBC. Even the regular those who are handling advances business, particularly corporate lending, they lack. If when they are in good repayment, they may not think about all these things. But sourcing people, at the time of lending, they should know all these codes. That is still a challenge in banking aspect. Only the specialized people, those who are handling distressed asset division, they may know all these things. And it's banking awareness also required. Then maybe I predict after another 5 to 10 years, currently the total IBC cases in various NCLT, particularly NCLT, NCLAT and High Court and Supreme Court, the total cases are above 8,000, including resolved cases, 8,000 plus cases. The currently only PPRP, 40 plus cases because of the last 3 years experience. I predict after 5 years, PPARP cases may be very high. Because currently it is not properly listed in the appropriate forum. It's all out of court settlements are happening out of court, not settlement. We may, the right word may be out of court negotiation. The number of the court admission cases is limited now, but there is a high possibility of pre-packed insolvency may be the, in terms of, not the value-based, in terms of number of cases, after 5 years, PPARP may be the number one in within the IBC segment. So the background behind these PPARP, the MSME role in India economy. A lot of startups are there. It's a limited company only. There are a couple of public limited companies. There are a couple of private limited companies. There is a lot of challenges also. Even the equity-based company, debt-based company, lot of MSME companies are there in India. Lots of MSME company, because of their own challenges, there is a possibility of they may fall under the PPRP cases. That's why if PPRP not there, there may be a value erosion possible. Bankers have limited, the old pattern only they may do. Even the startup or whatever the company, there even the supply chain and finance, value chain based finance without SARFAESI. There are a lot of follow failures of bankers. Then there is no option. They need to come under PPARP. Unlike the SARFAESI kind of thing, it's all very limited in startup environment, and there are companies assessed through these MSME guidelines. Then there are a couple of failures. Still, the awareness is very limited. Otherwise, the number of cases may be very, very high. COVID-19 impacted the financial stress is very high among MSME sector. PPRP may be the reviving tool for them. The company can be revived. The merger and acquisition is possible. Not merger and acquisition, it may be the resolution. Job preservation possible. That's same kind of CARP outcome. The economy may boom. And the amendment happened in April 4, 2021 PPRP cases. Now it may give new life for MSME. Currently only the cases are only 40. There is a possibility of this may be the oxygen for the sick, not the sick company. Currently they may face the debt issue. They can come in the PPRP purview. Yeah, these are all. Yeah. Another thing is the key features of PPRP process. Already I explained. It's the pre-negotiation stage, informal to formal process. There are pre-negotiation stage. Actually, currently there is no, the timeline is very limited. As per the code regulation, the timeline is limited for pre-negotiation. But practically, the pre-negotiation can happen long time. I don't want to mention maybe approximately 3 months, 6 months, something like that. But code, the regulation is something very short time only. I'm talking about the pre-negotiation. There are informal discussions that happen between debtor, creditor, and the potential IP. Base resolution, where the IP eligible company can submit a base resolution plan with the help of IP. Normally, even the bankers are currently bankers. They may direct us or guide. Maybe they may request us to guide that debtor. There is a possibility. Then base resolution plan, stakeholder protection, both the creditor and debtor within the system. There are a lot of checks and balances also there. Limited court and IP role. Even the IP role also, practically the IP role also minimized, but still the informal pre-negotiation stock also, IP play a vital role. It is alternative to CARP for MSME companies. So these are all certain ordinance, IBC code, amendment by ordinance, that is PPRP rules, prepacked insolvency resolution process, separate PPRP rules there 2021. IBBA also frequently putting the PPRP, even if you are going to IBBA site, there are the separate voucher is available for PPRP. The interesting, even the complete, even somebody getting the first case in PPRP, that I think that brochure is 4-page brochure developed by IBBA. That is enough to handle the PPRP cases by IP. No need of any IP support or any other consultant, not consultant, because IP, maybe the external, the other advice that may not require. It's all user-friendly guidelines are available in IBBA site itself. Take on the goal be discussed. As per code, the eligibility is 10 lakhs and above. There are the common points there between PPARP and CARP. Section 29A compliance still applicable to PPARP. And corporate debtors should not have undergone CARP process or liquidation process last 3 years. Otherwise, if they already CARP or the liquidation in last 3 years, then they are not eligible. Normally, these kind of criteria may not come, because here the default amount is less, 10 lakh and above. Whereas CARP it is 1 crore and above. There is possibility of prior CARP cases or the liquidation may not be there. And there is even some MSME big company, even the micro, small, medium company, something like medium company, their volume may be high, then there is a possibility of CARP also. If already they are undergone CARP, then they are not eligible. And the biggest eligibility criteria is the point number 6. Here I put it in the slide. MSME status evidence. That needs to be verified by insolvency professional. That is fundamental criteria. Whether that company registered under MSME Act, under the Government of India Act, particularly Udayam registration certificate, and proof of investment and turnover. Based on that proof of investment and turnover only, MSME criteria will come. If their balance sheet is above MSME criteria, though they may registered in MSME once upon a time, the certificate validity and all. Another thing, another aspect is, at the time of registration, there may be a MSME company. But later, based on investment and turnover, they exceed MSME criteria, then they may not fall under this category. That needs to be verified by IP. That is fundamental criteria. the pre-negotiation stage itself, IP need to verify whether this company is eligible for PPARP or not. That maybe some banker may think that because of these 10 lakh and above cases, they want to put it in this case under PPARP. The MSME criteria, particularly not only Udayam registration certificate, the biggest classification, the micro, small, medium enterprises MSME criteria, plant and machinery, investment, the net worth, whether it is a service industry or manufacturing industry, as per MSME Act classification, whether they are fall under MSME or not, that need to be checked. That is eligibility. This is the typical process flow of complete PPARP process. There is a pre-admission stage. I think you all know everything, but just I reiterate first these things, then we can go to cases. Pre-admission stage. Mutual understanding. That means mutual understanding between creditor and debtor. Either it may be debtor, maybe the understanding, the negotiation may be debtor driven or creditor driven. It's all pre-admission stage mutual understanding. Sometimes practically, normally debtor will, practical aspect, debtor may not influence the bank for PPRB. I'm talking about the practical sense. Normally, the distress asset decision of any bank or NBFC financial institution, they may induce debtor. I'll give approval, creditor approval form. In the case, CLT for PPRP. Then we can look for that is possible. Then the list of data that need to be prepared by debtor with the support of RP. Identification of IP2 as a RP. Here, PPRP, no IRP term, no IRP, everything RP. And declaration by majority of director and partner, it should be written. It should be the board approval may be required. Shareholder resolution is mandatory. That is, shareholder resolution is 100%. The creditor approval is 66%. This is 100%. Even the partner, debtor, some 5 people there and one person is not interested, then this case will not fall under PPARP. But in the case of FC, the financial creditor or per se, we can say creditor, it should be 66% and above. Then this case can be filed in NCLT. It can be induced by debtor itself. Consent of majority of unrelated financial creditor, that needs to be obtained. Report of RP, resolution professional preliminary report is required. Application to adjudicate the authority for admission. Practically nowadays, these kind of discussions are taking, it is not even the regulation, the whatever the negotiation, there is no time bound, the restriction is there, it's all out of court thing. Practically it may take 3 to 6 months discussion or something like year-long discussion also happened between the debtor and creditor. Because once the case is fall under NPA only, bankers will force the debtor to take the multiple option, particularly the one-time settlement, something like that. Going beyond one-time settlement only, they may think about the PPARP. That's where everything, before all these things, the time, the current practicality about the pre-admission stage time bound, it is not, it depends upon the debtor's negotiation. It depends upon creditor negotiation. It is even nowhere, even that we may be, as IP, we may be just an intermediary. Both debtor and creditor, they may decide the course of action for PPRB. Then updated a list of claims, preliminary information memorandum that needs to be prepared by debtor with the help of RP. That is the biggest difference between CARP and these case. These case, debtor has more role. But anyway, without IP, they may not be able to, these pre-admission stage cases, IP play a vital role. Then base resolution plan. If the base resolution plan is approved by the financial creditor, the creditor, that approval is required. If everything, these are all parallel activity. This is application with the adjudicating authority. Then the adjudicating authority, after verifying all the required, maybe all the declaration, majority of the approval by directors, approval by the creditors, application, along with all the supporting documents, they may admit or reject. If reject means the case is over. Because the pre-admission stage itself, all the eligibility, all the process needs to be done by both debtor, creditor and the IP, the triangulation work. The rejection means then something, eligibility or something like that out of all these process comes. Then RB constitute committee of creditor. Already the committee of creditor may be there. It needs to be formalized. Then CD submit a base resolution plan. Here the word that is very important. In PPRP cases, corporate debtor submit a base resolution plan, not IP. But IP will assist the corporate debtor to prepare a base resolution plan. Then the creditor needs either case yes or no. If yes means what kind of basis of evaluation and alternative plans they may ask, that is base alternate plan, it is better than the base resolution plan, they will work out. No plan is received also, then they will direct the corporate debtor to prepare another plan. Then COC need to give approval. Then it is submitted to, if no, that resolution plan is not up to the level, then prepare closes without resolution. Over, no. Either then this course, that case may go to liquidation, not through NCLT. There is another process. There is no liquidation because the currently PPRP liquidation, separate liquidation process is not there. Even if they eligible for CARP, then it may move to CARP. PPRP ends with resolution, that's all. No liquidation. If liquidation means, then there is the separate process involved. The final adjudicating authority may give approval, then the another 30 days, something like that. Whatever the that resolution, the debtor and creditor will, or any potential resolution applicant, they will work out and they will design all those things. Currently, average, maybe the backslide it is done. The current resolution is, haircut is almost post haircut PPRD based on the 40+ cases. average resolution percentage amount in terms of amount 34 to 36%. If debtor have 100 crore, there is a possibility of the 34 crore resolution by resolution applicant. Still haircut is around 65 to 70%. Still better than CARP. Most of the CARP cases. That's the typical process flow of PPARP. Then a model timeline for completion of PPARP under section 54C IBC, commencement of PPARP. There are PPARP 54C. Peacock. See, that is A to B number of the sections are available. Under section 54C, that is the appointment of RP, commencement of PPARP and acceptance by RP. I have an interesting case. State Bank of India appointed one RP for PPARP cases. All pre-negotiation happened, and that is not whatever I am saying. That is my practical experience. That is not listed in any of the NCLT orders. That means what the State Bank of India, they proposes one RP along with the even discussed with debtor. They put up application to adjudicating authority. The thing is still as like a CARP. Again, the NCLT verified the eligibility criteria of RP. Here eligibility means they may here the bankers and the debtor, both creditor and debtor proposes the RP name. While putting the application, they accepted the application, NCLT, but they did not accept the RP. It is all mutual consent RP, put it in NCLT, and the NCLT rejected the RP to handle this case, and they proposed another name based on the NCLT empanelment, and the NCLT, because State Bank of India, they may, I am talking about State Bank of India as a case. There, all banks, all NBFC, similar line only. Still, State Bank of India, through their empaneled IP, they submitted the application, but NCLT changes the RP name based on the, because of RP already has cases of CARP. That because NCLT may verify, or otherwise the particular RP can say that I have something like 8 cases or 5 already CARP cases are there. I may not be able to handle these cases. He is also not saying anything about this. State Bank of India, based on the existing relationship with the RB, the existing resolution success, they propose RB, but NCLT, they are the cases, they are not accepting the RB name. They proposed, they included as per NCLT empaneled IP and passed the order admission of the PPARP application. Then the State Bank of India people, they shocked. They They are more the comfortable, they may their own empaneled IP. But the proposed IP by NCLT is not empaneled with the SBI. That's also interesting fact also there. Though the creditor and debtor jointly proposed on RB, there is a possibility of adjudicating authority reject the RP name and they may not propose. They may insert new RP and admit the case. That is a possibility. That's a live case. After admission of RP, list of claims, preliminary information memorandum, it needs to be prepared. Yes, everything already before putting in application, everything prepared. Here the timeline is T+2 as per the regulation of PPRP regulation of IBC. Then within T+2, publication of public announcement. If they look for any resolution applicant, then the public announcement, because of the list of claim is any fresh claim is coming, that needs to be checked. Then appointment of registered valuer T+3, where in the case of PARP it is T+7, but in the case of PPARP it is T+3. That's why any IP maybe pre-negotiation say something like that. Practically advocates, bankers, and the debtor, like this SBI case, they propose a own RBI and it go to NCLT and NCLT inserted another RP name. Then now the RP does not have any time. The register valuer needs to be registration of valuation. Maybe that needs to be even some other RP handle also. Still it is debtor controlled case. They may have done already the valuation. Then that needs to be again within the T+3 the appointment of registered valuer. That is in the case of CARP it is T+7, here T+3. First meeting of COC, it is T+7. Here this is also less than CARP. Then submission of information memorandum within T+14. Publication of invitation of resolution plan T+21. That is very crucial. Within 21 days of after admission of PPARB, publication of invitation of resolution plan needs to be published as per regulation 43. Then receipt of resolution plan. We may receive the resolution plan from potential applicant. That needs to be collated within T+36. Then evaluation and approval of resolution plan by both debtor and committee of creditor within T+18A. If it is approved, then the next 30 days, the complete process. Another important things the RP needs to done. The award and the buffer transaction, all these things needs to be done T+30 days. Parallelly, all these things needs to be done. Then the COC approval T+90 over. Then before 120 days, everything, even the order of termination of PPARB, that means closure of PPARB has to be done post resolution plan within 30 days, 90 plus 30 days. This is as per regulation, we need to do all these things. These are some of the forms we need to use it. Form 1 rule, as per rule, application of corporate applicant to initiate PPARB, separate forms already available. Now I think many advisory companies are providing digital forms. We can just type that can reduce our error. Form B1 Written consent by IP to act as RP and IRP. B2, list of creditor to be provided by the applicant. Here the applicant is debtor. Then 3 is approval of terms of appointment of RP by both financial creditor and here the creditor needs to accept RP also. And approval of filing application to initiate PPRP, that is United Financial Creditor, unrelated financial creditor also. That means regulated financial creditor, that means operational creditor. Everything, unrelated financial creditor also. They need to give consent. There is a possibility of unrelated creditor in every PPRP cases. Because that's all debtor-driven company. They may have individual, they may avail any individual finance also. That's where their own approval also required, because it may be the agreement may be between both the debtor and the unrelated creditor. Then their approval also required. Written consent by IP to act as an authorized representative if it is fall under authorized representative category. The number of claims are more means there is a possibility of authorized representative also in these PPRP cases. Till Form 13, everything need to be followed. Form 1 to everything available. We all know all these forms. We need to use it efficiently. Nowadays, all the digital tools are available to minimize error, typo error, clerical error. That can be sorted out by IP. Okay, these are all, whatever we are talking about, these are all the pure, first we talk about the myth about PPIRP. Second, we talk about the theoretical aspect of PPIRP. Now we are going to talk about, even the theoretical also in between, we are talking about the practical orientation also. Now we are going to talk about some of the cases also, some of the cases and the practical aspect of PPIRP. We can summarize. Meeting of unrelated financial creditor, that's all, that should be happen, both pre-admission stage and after admission stage also. Notice of meeting, that needs to be served. List of creditor in Form B2, approval of IP, as per the flow chart, we need to do all these things. Corporate application eligibility requirement, record of default, that needs to be get it from NESL. Now the utility, information utility data is almost all the financial institutions, they registered with information utility. In all our cases, only information utility NESL, all the data, all the record of default may be available other than the unregulated creditor. All the records we need to collect it. Then consent proposal of IP under Form P1, approval by EFC, declaration by directors. That's all pre-data already we talk about, and all the financial statement, all the balance sheet, the current cash flow, whatever the we need to even the potential income and expenditure, current income and expenditure statement, everything. These things, I hope the banker will support in practically, because they may not, but in the case of all these MSME, they are collecting this data frequently and they may support also, or otherwise we can get it easily. When compared with the CARP process, getting document and all, because these are debtor initiated cases and with the creditor approval, the data collection may not be difficult. the post, we are talking about the summary of the PPRP theoretical thing, management of CD, RP powers, PRP submission, claim submission timeline, everything we handle, then public announcement. These are all cyclic effect. Yeah, these steps for plan approval process. The first is non-impairment of claim. If the PRP-based resolution plan does not impair claims of operational creditor, the committee of creditor may approve it directly. Otherwise, operational creditor things also need to be considered. Invitation for competing plans. If the PRB does not impair claim, the resolution professional invites prospective resolution applicant to submit competing plans for consideration. Then the evaluation criteria. Maybe the evaluation may be done by the committee of creditor with debtor in consent. In CARP, that does not happen. In PPARP, though evaluation criteria assessed by the COC, still the COC may discuss with the corporate debtor. Evaluation criteria, then select of best plan. There are maybe the available 4 or 5 resolution applicants, something like that. The best plan can be, if any is required, that is also possible. They can again go with the resolution applicant. The improved plan can be possible, whereas in CARP, that is practically not possible. But in the case of PPRP, still the resolution plan can be improved. CARP, the process, everything needs to be, because resolution, the period resolution, still approval is adjudicating authority. The thing is, because of the negotiation and the debtor control in nature, the still improvement is possible. But in CARP, once the resolution plan put it in adjudicating, here also, before adjudicating authority, everything needs to be done. But in CARP, even all these negotiations and all, PPRP is very, maybe the discussion may be very deep. CARP, it's all procedural nature, and it needs to be as per code and regulation. And everything closed. That means if PPRP cases resolution is done, means then again the approval is required from adjudicating authority. The 90-day expiration means over means everything over. Adjudicating authority may not give extension. CARP extension is possible, but in PPARP, as per, I am talking about as per code, but as per there are few NCLT cases, given the extensions also given. But in as per code, extension may not be possible. If resolution is rejected, then it is over. Then the financial creditor and debtor need to take another call. They can go for CARP or liquidation. Otherwise, everything over. Liquidation means not automatic. PPRP, then liquidation. No, liquidation may be voluntary liquidation, something like that. It is not the regular liquidation. Regular liquidation means then the default amount, something like that, the eligibility criteria. There is no MSME liquidation code. PPRP for MSME, but liquidation is as per the IBC code, the IBC within CARP, the liquidation model, but not as per the PPR, as related with the PPR. Resolution plan is rejected, then automatically liquidation? No. Everything over. Then they can they can go with voluntary liquidation. No, voluntary liquidation also practically not possible, because voluntary liquidation, creditor, if any debt is there, voluntary liquidation may not be possible. Then they may not, the default penalty is very higher. Then they can go through CIRP. Then COC termination approval. COC also need to give approval. Then CIRP conversion. RP can file CIRP. If CIRP is over, then the PIRP may be over. Then as per CIRP, then again CIRP means then there IRP role play vital role. If it is go interim, then it may go to the resolution RP case for resolution application purpose. Then if it is the resolution not happened within time frame as per CIRP, then liquidation may go. That is different part of PPRP. There is no way link with PPRP and the CIRP liquidation. There is no link. Maybe now the cases are very minimum. Over the period, the linking of CIRP and PPRP may come. Currently, the big no, everything over. If the resolution is over, the final process flow, initiation phase, pre-negotiation stage, preparation plan, stakeholder approval. Again, why I am repeating? Maybe we all know in the simplified manner. Then whenever we have a doubt, then the process flows in order, we can do proper resolution, implementation of plan, monitoring and adjustment, and closure of process. There are separate roles for all the people. Corporate debtor role, resolution professional duty is completely different from CIRP process. Here the resolution professional, actually when compared with CIRP, PPRP, though it is a debtor control, resolution professional play a vital role. I think everything, I am talking about the practical thing. Creditor depend on us, practical way. Debtor depend on us. All the documentation, all these regulatory monitoring kind of things, the creditor and debtor may ask RP to all these duties. Then the creditor responsibility, attending the COC meeting, resolution plan approval, these kind of things, creditor responsibility. Transparency and communication, when compared with transparency and communication, when compared with CIRP, PPRP is something lacking, practically speaking. And timelines of action that needs to be, compliance with the regular updation, that is also need to be done by RP. Document submission, stakeholder engagement, these are the responsibility need to be taken care. Required form already PPRP overall it's a structured approach, though it is a structured approach, still a lot of things, particularly digitization and the documenting the pre-admission cases or out of court things, that is lagging, that needs to be streamlined. Then the learning experience of other IP may be possible. Otherwise, only way is getting information directly from particular IP. That is only possible. The currently in all CIRP cases, whatever we want, we can learn it through IBBI portal or the NCLT platform. We can learn it. But in PPRP cases, that learning is very limited, very limited. When compared with the pre-admission cases, Even the post, there are certain confidentiality nature. Listing of all these cases in NCLT platform is very limited. That is biggest challenge. Business continuity, that is possible in MSME because of PPARB. Otherwise, the one-time settlement only possible. That is the death of the company. But the PPARB can revive the company. And it's a valuable tool. All these regulations, it is practically very new. But I know those who are currently handling cases with the banks, you may know these PPARB, the distress asset, either AGM or DGM level people, they may discuss with us about this PPARP. There is a possibility. These cases may mushroom across all the NCLT. But awareness and understanding, still there are certain hidden points. If it is everything resolved, the number of cases in PPARP may be very, very high across India. With this, I maybe we can take 10 minutes break. After 10 minutes break, we can discuss. Maybe some of you may already handle the PPARP cases. You can, I request, you can share some of your experience with PPARP cases. That maybe give much value to this virtual workshop. Now the time is 3:25. Again, we can rejoin at 3:35. 10 minutes break. You can take 10 minutes break. Again, we can restart with practical cases. There are, I have around 10 to 15 cases. We can talk about those cases, how the NCLT treated PPARP cases across NCLT, not only one NCLT, across India, how these cases, the gist of the cases, what outcome came from NCLT, that we can see, pure PPARP cases. There are certain interesting cases are there that can see post break. Maybe you can all join post 3:35. Okay, again we can start. I request anybody handled, I think definitely you will handle already handled PPARP cases. I request any the fellow IT, you can share your own experience. Whether anybody handled PPARP cases? Okay, I understand. It may be. I'll maybe talk about all these analysis, practical cases, PPARP 21, 22 cases. The detail, there are a couple of cases happened in 2021. These are the cases. NCLT, Bench, Ahmedabad, New Delhi. Most of the cases happened in New Delhi in the after amendment of these PPARP cases. GCCL Infrastructure and Project Limited. They filed under section 54A under PPARB. The debt amount is 54.16 lakhs. MSME certificate also produced. Resolution profession is IP Parak State. The case is admitted and moratorium declared under section 14 of IBC. RP appointed. That is the final outcome. And then the Truth Builders Private Limited versus Skyscraper in infra project, filed under section 54C IBC, pure PA, because all negotiation, everything happened, then they put all these applications. The financial creditor objected during the admission stage. This case is withdrawn, dismissed, because creditor approval is mandatory. These are all initial cases, 2021, 22 cases. Loon Land Developers Limited filed under section 54 IBC. Default amount 10 lakhs, operational debtor thing. RP is IP Nilesh Kumar Senga. There is admitted and the moratorium declared, RP appointed. Then the CHD develop. These cases we are going to discuss about what kind of any landmark judgment is there. We are going to see. And the CHD Developers Limited, there is a conflict with pending section 7 IBC application, CARP. Priority under 11A IBC, the PPARP case dismissed and section 7 application admitted. The case is already there in CARP and parallelly they put it in PPARP, but court, because it is prior to PPARP, then the case, the CHD developer case is rejected by NCLT Bench, New Delhi. EN&P International Limited, that case also 54 under section PPARP case 54C. Debt amount is 12.53 lakhs. Resolution plan also submitted. Then everything over. That's a clear-cut case. Analysis of these 5 cases. Case 1, case 3, case 5 were accepted under PPARB. Cases 1, 3 and 5 are accepted under PPARB. Under section 54 A and C, including MSME eligibility, again the creditor approval. That is, and the case was withdrawn. With the withdrawal case number 2 is withdrawn due to the creditor not accepted, the creditor approval is not obtained properly. Then section 11A ABC IBC ruling, the tribunal under section CARB 7, 9, 10, the amendment take precedence over PPARB, affecting case number 4. That means if the case is filed under CARB and parallelly they put it in PPARB, then CARB rule, not PPARB. That's these 5 cases. In the initial period, 5 cases. These are all listed in even the listed in NCLT, and now it is available in public domain. Now we can go to the initial stages. The initial stages, there are out of 5, 3 cases admitted. 1 case because of creditor not accepted the consent. That case is we can call it as a withdrawn. Then the overriding effect of CARB. Because of that, 1 case is happened. The 21-22 out of 5. 3 cases admitted. And even you cannot find about all these resolution plan in public domain, because these are all the PPARB most confidential nature. That's where we may not found the detailed how much debt, who are all the debtor, who are all the creditor, what kind of resolution plan, how much is the haircut, something like that. It is not available in public domain. There are a couple of after 21-22, how many cases? The 23 is high number of cases filed under PPARB when compared to 21-22. 24 limited, 25 as per the NCLT data, only 1 cases, fresh cases filed in under PPARB. That means 23 is very high when compared. Almost 20 plus cases are filed across NCLT under PPARB. This is the landmark judgment, case analysis of Ampersand Foodstuff Private Limited. This is first successful PPARB case. Legally, first successful PPARB case of IBC. Under IBC, it is Ampersand Foodstuff Private Limited. This background about this case, the period to the corporate debtor name is Ampersand Foodstuff Private Limited. It is classified under MSME. Insolvency triggered post COVID, inability to repay debt, and economic slowdown. As per the PPARB, all the pre-admission stage process completed. Then it is put it under the PPARB. Section A fulfilled. Section 54A. That is MSME classification. That as per IBC 54A, whether this case is fall under falls under PPARB, eligibility is checked. Case proceeding happened with NCLT. 66% of financial creditor obtained approval. The corporate debtor obtained creditor approval before filing. Application filed NCLT Mumbai. Actually, the first case is logged in first successful case. We are not talking about first logging case of PBRB. First successful resolution case is at NCLT Mumbai under section 54 A IBC. NCLT admitted, here the wrong word, RB admitted, base resolution plan submitted by the Ampersand management. No third party resolution applicant involved, unlike CARP. Here the creditor approved the plan as the approval need to be obtained from creditor. Then NCLT approved the plan, finding it on all stakeholders, everything cleared. And as per resolution, they resolve the company. Resolution done. This is under MSME, this insolvency, PPARP, the debtor retain control, the company is still alive. It is and within 120 days it is completed. It is avoided liquidation, preserving job and business continuity continued. Creditor recovery, better recovery when compared with the liquidation. Even when compared with the CARP also, the creditor recovery is high in this first case. This first case depicted validates the PPARP as an effective tool for MSME, balancing both their debtor and creditor rights, reduces the burden on NCLT. There's lot of jobs are done by RP. All the pre-admission mediating role done by RP, though it may not explicitly written in anywhere, but the RP play a vital role. And the faster resolution with minimal judicial intervention encourages more MSME to opt for PARP instead of lengthy CARP or liquidation process. These are the impact of this first successful case. This is landmark judgment. The second case, GCCL Infrastructure and Project Limited. The GCCL filed the application under 54A MSME PPARP. The corporate total debt is 54.16 lakh. All special resolution, board of directors resolution obtained. Creditor approval obtained, 60% in value. Resolution professional Parak Seth appointed as IP Parak Seth appointed as resolution professional. NCLT admitted the application. Moratorium starts. PPRB under section and case this also success. Then GCCL successful. Then the Group Builder Limited and Skyscraper Infra Project Limited case. This is also under section 54C. Application is filed before NCLT. The biggest problem, this is actually all pre-admission, everything that is the expectation. Pre-admission, the debtor need to get approval consent from creditor, and the RP needs to collate all these mandatory things before putting it in NCLT. But they put the application, then the creditor withdrawn the creditor not given consent. That's why this case, though the case is filed in NCLT, but it is withdrawn, or we can call it as dismissed. It emphasizes need for proper filing by the corporate debtor. the corporate debtor not get even the creditor approval is needed, the appointment of RP, everything. But that's where the RP play a vital role. But in this case, even they are not penalizing RP because the case initiator was corporate debtor. That's where IP not penalized because the creditor not given consent. Then another case, Loon Land Developer Limited. This is 2021 case only. Section 54C under this PPRP thing. Compliances, pre-admission process, everything checked by RP and the MSME registration also done. Special relation obtained. Approval of financial creditor also done. Appointment of the IP Nitesh Kumar Sinha appointed as RP. NCLT admitted the application, imposed moratorium and direct RP to proceed. Application admitted and public announcement, everything done. This case also resolved. The resolution, successful resolution happened. Loon Land, these are all initial stage cases. Loon Land Developer Limited. This case, the entire details available in public domain. Now we can, as IP, we can use it. These are our model for stemming. If we may get any PPRP cases, we can refer these things. And CHD developer, this is interesting case. CHD developers, actually case filed in CARP filed in 2020. Then after amendment of PPARP, parallelly post CARP, PPARP also filed by corporate debtor. But after analyzing the section 11A of IBC, NCLT rejected the PPRP application and CARP overrides. CRB application admitted and an IRB appointed. That's where the eligibility criteria or something like that, that's after and before. Something like that, CRB is there, whether PPARP can be done? No. Possibility is PPARP cannot override CARP process. That means PPARP is will not be accepted by adjudicating authority. That is the outcome of this case. CHD Developer Limited. This is ENNT International Limited. This is another interesting case, but the debt is very huge, 12.53. Actually, because of MSME, this case comes under PPARP. Otherwise, ENT is eligible for CARP also. But they have the agreement between creditor and debtor. The consent is there, means a faster resolution. PPARP is possible. Instead of CARP, the PPARP route is efficient. This case depicted these things. Special resolution, director declaration, that the creditor approval, everything obtained, and the here in this case approval, the financial creditor is State Bank of India. RP is Ritu Rastogi, CA Ritu Rastogi. And the NCLT also admitted the application and directed the RP to proceed further thing, and the RP tasked with the public announcement and interim report demonstrate RP role. Actually, this case, it's even in deep, even around 24 pages are there in the portal. This is interesting case. Actually, This case is also eligible for CARB, but because of understanding between the corporate, even we can call it as creditor given consent, then the corporate debtor initiated CARP, the PPARP instead of CARP. This is the successful, within short tenure, the resolution done. Amrit India, this is actually this is the first Amrit India is another 2022 case. The default amount is 12.25 lakhs. All compliances, all the pre-admission formalities, the MSME registration, special resolution by board company, then the approval of financial creditor obtained, RP also appointed, then the NCLT also approved, public, this is also one successful PPARP cases. Within timeline, this case is resolved. Amrit India Limited. Key takeaways from these cases, particularly 21-22 period cases. The PPRP is very faster, cost-effective mechanism for MSME with a 103 days timeline. Strict compliance, the section 54A, director declaration, MSME eligibility, creditor approval. That means it's like a, in banking line, it's like a one-time settlement is something different. But here it is, everybody consent has taken, it's out of court declarations. Role of resolution professional here, all these cases, role of resolution professional is verifies claims, ensure compliances, oversees the resolution plan. That's all. Rest all taken care by both the debtor and creditor. The submit interim report, manages creditor communication, and there are certain cases we talked about the conflict with CARP. Section 11A, prioritize pending CA. If anything, any application there in any court, CARP application override PPARP. PPARP cannot override earlier CARP proceeding. Successful PRP cases result in moratorium and resolution plan implementation. Unless CRP, post CRP, if failure of a resolution plan, there is a possibility of liquidation. But in PPRP, no liquidation. Either successful resolution or maybe dismissal of resolution plan, that is only possible. Yeah, Sri Rajasthan Syntax Limited, another case. This is at Jaipur. Most of the PPRP cases are there in Delhi. Almost 70% of the PPARP cases, past cases across India is in New Delhi NCLT. Then remaining cases in Mumbai. This is a rare case in Jaipur. Other NCLT like Chennai, Kolkata or other thing, it's very limited. Most of the 90% of cases are there in Mumbai and Delhi and first Delhi, then Mumbai. These Sri Rajasthan Syntax Limited, this is NCLT Jaipur branch case. IDB, there are the consortium of banks, State Bank of India, IDBI Bank Limited, Bank of Baroda, resolution professional appointed, IP Dr. Lekraj, Bajaj. This case is also approved by NCLT. All the stakeholders approved, and it's a successful PPARP case. This is maybe the delayed case. What we can we are saying that 90 days plus 30 days, 90 days, 30 days. That is because of the judicial formalities. This day is more than 120 days. Sudal Industries Limited. There are a couple of hearings happened. National the NCLT Mumbai bench. The case logged in 2021. The final order came in 2023. Almost 2 years case. But as per PPARB, it need to be completed within 120 days. There are exceptions are there. It adjudicating authority, the God will say the adjudicating authority is here God. They have after 24 months, this case is resolved. This is exceptional case. Total debt 13.321 crore. 13.21 crore. It's a clear-cut CARP case also. But anyway, the entire process completed as per CARP. Though the name is PPARP, the case is resolved as per CARP. Resolution clause approved and it is binding on all stakeholders. Sudal Industry Resolution Plan approved under PPARP. But it's a clear-cut case of, though it is PPARP, it behaves like a CARP. That means based on timeline. But that RP or corporate debtor or creditor, they cannot decide. Adjudicating authority, code and regulation may be different. By practice, there is a possibility, like CARP also. Some cases going beyond timeline with various reasons. This is clear-cut case going beyond PPR time frame, PPARP time frame. This ENT International Limited already it's a highly successful case and resolved it very quickly. Even the case is initiated in October 10, 2022. October 19, 2023, everything over. So almost 1 year. Even still, it is not resolved within 120 days. But when compared with many other timeline of CARP, this is clear-cut. This is practically 1 year case. 1 year, within 1 year, everything resolved. ENT International Limited. Another interesting case, Karodia Chemicals Limited. This is the case is rejected. The biggest of SEBI takeover code trigger in this. It's a listed company, Karodia Chemicals Limited. SEBI, the control listed some kind of regulation. That's where the company outcome, the company petition rejected. There is a possibility of, though all pre-admission, something like that. Here, another regulatory authority, SEBI, also involved because of listed company. This case is rejected. Karodia Chemicals Limited. If you want the PPRB, only few cases, PPRB cases rejected because of these kind of things. Because this is a listed entity case. Karodia Chemical. Then Mutra Lifespace Private Limited. This is also Mumbai Punch case. The case order is 2023. It's this is quick. Within a timeline, this case is resolved. Mutra Lifespace Private Limited. The understanding between or the resolution between the debtor and creditor is online, and the NCLT approved the case. Here in the judgment, they mentioned management of the corporate debtor shall remain vested with the board of directors. That's the beauty of PPARP. So these things, we can summarize these cases, analyze the various things, whether it is approved or whether it is rejected, whether CARP overrides PPARP. Another thing is the creditor approval is necessary. Then the another interesting case with the Crodia, the SEBI. If any regulator involved in this thing, there is a possibility the IP need to be very careful if it is a listed company. Now the current cases, these are all current cases. That means 24, 25 cases. What we are talking about earlier, between 21 to 23. Now the 24, 23, end of 23 and the up to 25 cases. The how the present situation. That means the current scenario, how cases are dealt in NCLT. Cathos tiles. The initial presentation I mentioned the Cathos tiles. Cathos tiles, the Indian bank objected alleging procedural non-compliance. That means lack of notice of creditor meeting. The 67 point approval, but Indian bank objected. Still, the creditor approval is 67. The only thing court mentioned is the RP must ensure creditor communication transfer. That means Indian bank objected that they are not concerned. Something like that because of the creditor meeting not informed. Something like that they complained with the NCLT. In the case order, they direct the RP to ensure communication transparency and adhere timelines also. They mentioned Cathos tiles. This is current case. Srimati Fashions Private Limited. Creditor approved the case 89.26%. PPARP admitted. Purvi RP is IP Purvi. Then highlight here the highlight is importance of creditor coordination and RP role in evaluating viability of the resolution plan. That is mentioned in the order. This is Kratos Energy and Infrastructure Limited. This is a recent case, 24-25 case. Resolution also, the listed company, that is corporate debtor, proposed 50% target for creditor. Declared deferred by the Committee of Creditor Review. Though this PPA finder to ensure SEBI dispute, resolve the regulatory dispute. But the case is admitted. Kratos Energy and Infrastructure. This is a clear case for us. If we may get any listed company PPARP cases, then we can refer Kratos Energy. KVAR Towers Private Limited, this is a real estate MSME. Zero revenue short PPARP. Tribunal flagged potential misuse of the adjudicating authority. Highlight the real estate case may fall under MSME means that's a false route, something like that. But they have mentioned, but the case is admitted. RP also admitted. The court again. The interesting fact is that though it is a real estate case, MSME regulation needs, MSME guidelines, MSME eligibility need to be monitored properly by resolution professional. post-admission compliance. That means even in between the time the amount, something like that, it is going beyond MSME category, means it is the case for vulnerability also. If the company go beyond MSME limit, then this case will not be fall under PPARP case also. When the honorable judge mentioned the court order, KVAR Towers Private Limited, this is the real estate MSME. You need to ensure the MSME classification. Even actually pre-admission stage itself, it is clarified. Even during the case also, it needs to be monitored. Karodia Chemicals Limited, again, the Karodia is an interesting SEBI case. Even the previous slide, the NCLT is rejected the PPRP application. NCLAT, the case is fall under NCLAT. Then, though it is rejected in NCLT, it is the case is admitted in NCLAT. Manish Modilal Judge IP is appointed as RP. Then the court ordered the proper resolution plan comply with the security, even with the SEBI security law need to be ensured. So the initial stage, this case is rejected by NCLT, but in the apex party admitted the case with the condition the RP need to ensure the compliance with the SEBI also. This is Karodia Chemicals Limited. Katos Tiles Private Limited. This is interesting case. Katos, the case number 1 is Katos only. Katos is case number 1. The same. That means the RB 60 days extension of PPARB, but the tribunal terminated the process due to non-compliance with section 54D. No plan within 120 days. It cannot go beyond 120 days. This is a clear extension. Because RP, the corporators are asked for extension of PPARB, but court rejected the case. Another thing is RP conduct, IP, the insolvency proportional conduct also criticized by NCLT. IBBI given warning to the concerned RP because of strict adherence to timeline is critical. Failure may lead to termination and disciplinary action. IP may face. This is Katos Tiles. Because the corporate, though the case is initiated by corporate debtor, but RP also involved. Finally, though as like CARP, IP received a disciplinary action from IBBI. Court also directed Katos Tiles Private Limited PPARP case. That's why IP need to be very maybe pre-admission stage itself, we should be very careful. Otherwise, once case is, even whatever the pre-negotiation, whatever the thing, it should be pre-admission stage only. Once the case is filed and admitted, then RP should be very careful. Otherwise, there is because of timeline extension, RP may face disciplinary action from IBBI. That is tricky. And what happens? Instead of PPARB, the case is transferred. That means the case against put it in NCLT for CARP. CARP initiated. The landmark judgment is RP cannot continue in CARP if they acted in PPIRP. PPRP, the case is terminated. Then again the case is come for CARP. The same RP cannot act as a RP or IRP. Fresh appointments are required. This is landmark judgment. Ketos time in this case found and case G Security India market. Tribunal admitted and the case is success. This is recent case. Within time frame, this case is resolved. Key takeaways for insolvency professional based on the recent judgment 24-25. Timelines very much. Keto styles case is clear-cut case. Extension rarely granted. MSME compliance. Verify MSME status again and again. Not only pre-admission stage. Even during the PPRP time also, already court orders are there. We need to check periodically MSME status. That means the balance sheet analysis. If it is, whether it is the net worth of both the plant and machinery category, the net worth category, whether it is fall under MSME and or periodically RP need to verify. Even during the PPRP time. IP, another important takeaways from recent judgment. Transition to CARP means the existing PPARP RP cannot act as the RP in CARP case. First appointment are required. Again, important factor is creditor coordination is very important. 66%, and even the 67, 70% approval also Indian Bank case. Indian Bank object. Even then the court may order IP to get proper transference way of communication, something like that. Anyway, IP will face all these consequences. Regulatory issue, address dispute if it is a listed company. Even the GST, SEBI related problem, regulatory issue, that needs to be properly handled by insolvency professional. Misconduct. There is a possibility of termination of IP IDs and disciplinary action may imposed by IBBI. PARP cases emphasizes IP compliance, creditor consensus, timely resolution. Transition from PPR to CRP require careful handling to avoid conflict. Tribunals are increasingly scrutinize MSME eligibility. Again, we are repeating the case also. Again, repeating because the fundamental of PPARP cases are based on MSME eligibility. That things periodical assessment is required. And this is all about the cases. Now, there are the recent amendment about the personal guarantor involvement. The PPIRP cases across NCLT with personal guarantor, there are few cases, personal guarantor also involved. Then we have, as per section 54A to 54OP, there is no mention about the personal guarantor involvement. Though it is mentioned that the subsection, there are other CAs, the certain CARP, the code of conduct and all, everything can be followed, and IP appointment, the criteria for selection of IP, that are based on CARP. That means the CARP section. The PG is something trick away. Even if the first case, the key takeaway is financial credits are initiated parallel proceeding under Section 95. Section 95 talk about personal guarantor involvement against promoter. That is separate process. Key takeaway. Then the RK Industries plan approved within 120 days. Creditor filed for personal guarantor insolvency post resolution. The enforcement can happen post PPARB resolution. That is possible. The key takeaway is whatever the cases, maybe the Amberson Food Stuff Private Limited, RK Industries, Keyboard Engineering Limited, Vijay Kumar Iyer versus Financial Creditor, NCLT Mumbai, all PPARB cases, S&S Power Limited, SK Wheels and Private Limited. The key takeaway is creditor have reserved right to pursue PG later also, maybe later with the DRT. That is possible. Personal guarantor, individual insolvency. If the case is over, that is also the key takeaway is that. But this is unknown. What we can say, maybe IBC may take all these the class or whatever. There are separate regulations, but there is a conflict of regulation rules are there, and I think IBC may take these things in consider in future. We may receive some kind of amendment also. The PG involvement related with the personal guarantor involvement. The interesting, what are the emerging trends from NCLT and PPARB on personal guarantor? PPARB does not discharge personal guarantor automatically. That is separate process. Dual proceeding allowed. One end NCLT PPARB cases, another end PG insolvency for promoter. Both can be PPARB cannot be same, but for personal guarantor, there is a possibility of parallel proceeding that is possible in PPARB. This is maybe what we can say, some kind of the conflict or some kind of all regulation code is not there. That's where still dual proceeding allowed in PPARB cases or PG cases. Creditor must specify personal guarantor waiver in resolution plan. That should be within the resolution plan. And limited case law. Since PPARB cases are very less, these cases are very, very less. NCLT cases mostly Delhi, Mumbai and Ahmedabad, particularly PPARB, PG cases. Otherwise, the lack of experience, we may face challenges. If any cases with PPARB and PGs, RP, IP need to be very careful because dual proceeding also allowed. In Chennai also now the PPARB cases admitted, but the case is not there in the public domain. In the portal it may not be there. Likewise, all over India, not all the cases are listed because of the confidentiality in nature. Not all the PPARB cases are listed in public domain. Even NCLT Chennai, there are few MSME PPARB cases are pending, but that is not listed in the order. NCLT order is not there. Still it is evolving stage. I think we may expect a lot of amendment, new regulation we can expect. And for PG implication, personal guarantor implication, encourage creditor to be explicit about PG waiver in resolution plan. Otherwise, the filing of case at NCLT may be possible post PPARB cases also. Now, the final thought about challenges in implementing pre-packed PPARP cases. Low filing, abysmally low filing. Though pre-admission, negotiation, everything happened. Low uptake and awareness is very less. Creditor-related challenges. Difficulty in obtaining 66% financial creditor approval. That's also challenge. If that is a multi-lender consortium kind of arrangement, then it is very difficult. These are another difficult. Actually, this is the biggest difficult for both debtor, creditor and IP. Judicial and procedural delay. Even we have seen one case is successfully resolved after 24 months. But as per PPARP cases, it needs to be resolved 120 days. That's why judicial and procedure delay also, though it is mentioned in 120 days, still this case is going beyond 120 days. There are governance and transparency issues in PPARP cases when compared with the CARP. And financial consent for MSME, the high cost and fees. The corporate debtor may incur costs to put this. Again, that is already in debt. Again, they need to spend money for legal, for these negotiations, IP costs, court proceeding, or all other costs. Still, they need to spend money. That is another financial concern. The biggest problem is limited post-insolvency financing. Even the successful resolution, banker will not give further lending. Though resolution, everything done. Though the company in running condition, post-resolution, the biggest problem is if they want more fund from same banks or any other new bank, it is very, very difficult. Once that's where the PPARP cases are not come to NCLT. Limited post-insolvency financing. Maybe creditor can push the debtor to put PPARP cases, but when considering when compared with one-time settlement, even the one-time settlement, there is a negotiation arrangement with the bank. If I pay all the amount, whether again you need to again refinance certain amount, then bank may accept also based on existing practice. But the problem in a PPARP, limited post-insolvency financing. Threshold is section 20, because most of the PPARP cases, even resolution within the family is also possible. Then the section 29 may impact them. Though resolution may be available, but still section 29 is applicable to PPARP. It will further challenge the corporate debtor. And the default threshold, lower default threshold of 10 lakhs for PPARP, but higher threshold for competitivity. If PRP impairs operational creditor debt, might incentivize some creditors. These are all some challenges. But what we can conclude, if PPARP is a promising avenues for MSME resolution, but practical implementation, we need to, as IP, we need to be very careful. Low awareness among stakeholders is a significant barrier to effective PPAR implementation. I repeat, after 5 years or after 10 years, PPARP cases may be very high when compared with CARP. Because of some the current challenges, the number is not increasing. The challenges in creditor consensus hinder the smooth functioning of PPARP. Procedural hurdle complicates the PPARP process and deep potential user. Concern related to transparency affect trust in the PPARP system that need to be addressed. Otherwise, these cases will not come into NCLT picture. Target awareness campaign is required across country. Streamlining creditor approval process is also crucial. Timely judicial oversight. Refining the framework. Balance debtor in possess and creditor safeguard also critical. Achieving this improvement will further help strengthen the MSME sector in India. Yeah, now though I conclude, there are opportunities for insolvency professional in pre-packed insolvency resolution process. What kind of avenues? The pre-admission stage process, the IP have even now bankers are pushing IP to solve those kind of pre-admission things. I think some kind of regulation for those things, or otherwise, if the skill is high at the IP level, there is a possibility of earning opportunity for IP in pre-admission stage cases, even before admission, or if the case is not come to the admission also, there is a potential opportunity for IP to handle those the period to PPARP process. PPARP thing, that's a regular. Pre-pack negotiation, there are multiple IP can involve, particularly preparation of base resolution plan or the MSME restructuring. That is some kind of eligibility things. Then the IP can guide properly the corporate debtor. After PPARP initiation, that is very crucial. Already I explained all these things. Fast track timelines and efficiency benefits for IP. Nowadays we are filing case in CARP and we are waiting for 2 to 4 years, and our earnings are very delayed. Sometimes we are spending our own money. But in PPARP cases, there is high chance of IP get even the initial payment, and as per the IBC guideline, the earning also within short time, IP can get their remuneration based on their work. Particularly debtor submit RG name and plan, that time we may get the remuneration of post admission of application, resolution time, post NCLT approval, the resolution time, everything is a earning opportunity and potential earning opportunity. Though the number may be very high, the case wise, volume wise, amount wise, it may be small, but with timeline, within quick, maybe very short duration, IP within 30 days, certain amount we will get it. It may boost our own profession. We can concentrate CARP with those money, and later we may get their remuneration. We need not spend our own money for PPARP process because it is debtor driven. Debtor will give all the money. That is the huge opportunity for IP. IP can get, other than the RP role, advisory and consultancy roles, valuation and due diligence services, training and capacity building, expanding into cross-border insolvency. Though it is in initial stage and no separate guidelines currently available, only discussion papers are there. Once the cross-border insolvency put it in place, under PPARP cases, IP, other than the court proceeding, IP may get additional opportunity in market. The biggest, even the one end we are talking about the opportunity. Challenges, even if we resolve all these challenges, IP may benefit out of these. These are all opportunity for us, particularly high scrutiny by NCLT. That means we are not blaming scrutiny by NCLT. That is the role of the NCLT. We need to adhere it. But the technology, there are enough technology is available. Still, the technology usage in that segment is limited. If that is improved, then the IP opportunity may go up. Another is conflict of interest allegation between corporate debtor, creditor, between creditors. These things need to be resolved. And limited, if we want to check any case reference, we have only limited judicial precedent. That's where it is very, unlike CARB, there are 8,000 plus cases are there. But in the PPIRP cases, only 40 plus cases are there. That too in the initial stages. That's where if more number of cases, more number of experience, more number of order, more number of resolution, we may get additional opportunity. Another problem we are facing is resistance from operational creditor. That is the biggest challenge. Enhancing profile for PPIRP role, specialized in MSME insolvency cases, that is PPIRP cases. There are some IP, they can be treated as specialized PPIRP IP. That's something like in court, advocate profession, somebody may handle divorce cases, somebody may get corporate cases, somebody may get civil suits, somebody may handle criminal cases. Likewise, in IP profession, somebody already now there are certain IPs are handling that. Many are involving only real estate cases, something like that. Likewise, in future, not now, PPRP cases role IP may be not. It's not regulation. They should not handle all other cases. Not like that. Even the PPRP itself will give enough earning opportunity for IPs. And we need to be updated on PPRP case laws. Follow on NCLT, NCLA. The judgment is very important. And better negotiation skill, we need to be, that means better negotiation means we need to face many problems. As long as if we are facing problem, then naturally negotiation skill will come. That we need to get many problems, many negotiation things, many discussion, out of court discussion between the bank, corporate, particularly PPRP cases. That skill we need to build. Network with banks and financial creditors is very, very crucial for RP appointment. If we want PPRP, 95% of the PPRP cases are routed through banks and NBFC. That means we need to be empaneled with banks and NBFC properly. Not only empanelment, frequently we need to build a relationship with, though we may not have any cases, but we should periodically engage with the banks forum, periodically meet with the bank people, and any update came means we need to update with some kind of informal discussion. It's for relationship building purpose. Then naturally the bankers through empanelment or even without the empanelment also, some banks are suggesting the RP for PPARP cases. Though debtor have every right, but still the creditor play a vital role in appointing RP. And advanced certification, something like MSME, there are other laws are there. We need to get wherever possible, we can get the certification also. Up to this, my presentation is over. Now it is time for discussion. I request a participant, you can now, we can, any doubt or we need to do. Here, I'm not a clarified person, but we can discuss. Anybody want to ask any question or we want to discuss further, we can discuss now. Friends, please raise, maybe you can open up.
So thank you, sir, for a very interesting presentation on a new area. This is Shalini. I am a registered RP. I just wanted to check one thing. You mentioned that under PRP, one of the very important things which is monitored is the status as an MSME. So, and also you mentioned that 29A provisions need to be complied for submitting a resolution plan. There are some sub provisions of 29A which do not apply to MSME. So how does this, tie up? That is what I wanted to know.
Yeah, this is an interesting question. Still, it is under debatable. Even one judgment, they mentioned period before admitting MSME eligibility. One judgment, even after admitting MSME eligibility periodically. The 29A still in under discussion. Even after IP, anyway, we need to ensure the 29 section 29A involvement. That for these PPRP cases, it is very, very, very difficult. Madam, I agree that's a challenging point. Maybe over the period, trial and error only possible, or otherwise any amendment. Even I would suggest, I would maybe recommend, even I can, if IBC portal asking for any suggestion forum for these things, first, even 29 section, that should be some 29A, it should be some kind of freedom need to be given to both debtor and creditor for these PPRP cases. Otherwise, it may, one case they are mentioning section 29A is very important. That order is also there. But another case, it is not overriding, but they are not seeing. That is also possible. And maybe, madam, you are putting question. What would be the probable solution for this issue?
No, sir. Thanks for us shedding some light. As you say, there is no, I think, ready-made solution. Maybe over a period of time, some amendment has to come, or some case laws have to come to clarify this aspect.
Correct.
Thank you, sir.
Thank you, ma'am. Yeah. Now, this presentation, I'll try to put it in, okay, I'll route it through ICSI, IIP, and they may share with you all. This if required, I will share this presentation. Now itself I will try. Whether it is possible, I don't know. The file size is big. We'll try to put it here, or otherwise I will share with ICSI. They will share with you all. And you can reach me. This is my contact, and it is along with my presentation. It is there. It's all cross learning. You can reach me. I will also, if you are reaching me, I can also, whenever I record anything, I may connect with you all. Thank you. Now I'll hand it over to ICSI. I'll try to put it in chat box, this presentation. Let's see.
Sir, you can share the participants.
Okay, okay.
John, sir, am I audible?
Yeah, your voice is not properly audible.
For taking out time and taking session as a speaker on the topic rise of feedback in IBC resolution. Thank you very much.
Yeah, very kind of you. Very thank you. Thank you all, fellow IPs.
Thank you very much, sir.